Hello everyone and welcome to this new episode of the Privacy Rules Privacy Espresso series, a series of interviews where we go deeper into topics related to privacy, data protection, but in general the use of technologies such as, for example, artificial intelligence. Indeed, I'm very pleased today to introduce you to the topic that is the one of generative AI and copyright infringement. That is one of the big topics since the spread of using of generative AI to create new contents like images. We're going to delve into this topic together with Kyoung Min from the law firm Delight Legal. Delight is the exclusive member of the Privacy Rules Alliance for South Korea, and we will see how this problem has been a very relevant one in that countries as well as in many other countries in the world. And we're going to learn a bit more on which are the legal risks in using it without enough knowledge, as well as manage a company using this type of technology without the proper legal preparation to that. So first of all, I would like to thank you, Kyoung Min, for being with us today. And I think we can start with a little overview on the topic of the day. So what are we going to speak about more specifically?
Sure. Thank you, Alessandra, for giving me the opportunity. First of all, as you know, generative AI is a type of artificial intelligence that refers to techniques used to generate or transform data. So developing good generative AI involves training of large amounts of high quality data. So for example, OpenAI has admitted that they utilize large publicly available data sets, including third-party works, to train their AI, and admitted to copying an unimaginable amount of data for analysis. So because generative AI utilizes the results of training data to generate their own images, if the data contains the copyrighted works of others, it's possible that the outcome may be the result of copying or modifying the existing copyrighted works, whether or not that it was specifically directed to do so through the user's instructions. So, as a conclusion, there's an inherent risk that the images generated by AI may infringe upon existing copyrighted works. So, as for copyright infringement, it occurs when the infringer's work relies on the existing work and there's a substantial similarity between the infringer's work and the right holder's work. And it's not very difficult to assume that the output of generated AI relied on the existing creation, considering the training process. However, determining the substantial similarity is highly subjective. So, for the substantial similarity to be recognized, there must be a high degree of similarity between the existing creation and the AI generated creation, and there must be a high degree of similarity in the expression and aesthetics beyond just the mere the similarity of ideas, concepts, or materials. However, the AI is characterized by its ability to create new works based on the results of its training, rather than just replicating the same data, meaning that even though the image created by AI could be reminiscent of an existing creation, it's going to include many different expressive elements and aesthetics. So it could be quite difficult to establish copyright infringement against the outcome of AI. However, if in case generative AI created and used an image that's identical or very similar to another's work, which is quite possible, then it would be safe to say that there's a substantial similarity and there's copyright infringement. So, for example, in 2022, a Twitter user criticized generative AI and demonstrated that images of famous characters such as Mickey Mouse, Batman, and Super Mario created by AI were virtually identical to its original characters.
Okay, perfect. Thanks a lot for this brief, overview on the topic. It sounds very interesting, and of course, AI normally have to take data from somewhere, so it's not, something surprising that then when recreates images, in the cases, for example, that you were mentioning, those can be very similar and maybe too similar to images that are already existing and that are copyrighted. On the legal perspective about these, which are the risks for the people that manage those type of technologies? So which are the legal responsibility for copyright infringement, to be specific?
Okay, so I'll be talking about the legal responsibility from both the user side and the platform side. So if the image created by AI is recognized as infringing on the rights of a third party, the user of such image could also be held liable. To be specific, although it's the AI which generated the image, if we could see it as just a neutral tool, such as a camera or Photoshop, it would be difficult to exclude the possibility that the user of the image may be directly liable for infringement of rights. Therefore, if someone plans to use AI to create and use an image that's a variation of an existing character or work or portrait of a celebrity, he should always keep in mind that he could also be liable for the infringement. But on the other hand, there may be cases where the AI's training data is automatically replicated without any instructions from the user to generate the image. So the user could be utilizing the infringing outcome without even knowing it, without any knowledge. So we believe it's quite unclear whether the user could be liable in such cases as well, and it could depend on the reputation of the affected work. So our advice is that in order to avoid possible liability in such cases, we recommend the users to check as precisely as possible whether the output infringes others' work, for example, through image searches, and keep the records of such investigation for future possible liability. And on the other hand, in case of generative AI platform, it will not be easy to avoid legal liability. And in particular, direct liability may be an issue if the infringing output is generated regardless of the user's instructions. And in addition, the platform's aiding and abetting liability could arise as well. So in case of aiding and abetting, there's a famous Korean case law in which the court held that the provider of music streaming service, which was quite similar to Napster, was liable for aiding and abetting because it provided the service and supported the free streaming of music, even though it could have fully foreseen the possibility of copyright infringement. So based on the same logic, AI platforms may also be liable for copyright infringement. So for example, DALL-E 3, created by OpenAI, rejects any instructions to include the name of a public figure or to follow the style of a living creator. And it also maintains an opt-out page where the creators can request that their work be excluded from future training datasets. So in light of these examples, it would be advisable for the platforms to take precautions to ensure that their services do not violate the rights of others. And even better, we believe they should take steps to ensure that they are technologically capable of detecting and excluding any infringing outputs before they are presented to the users.
Yeah, that's a great point. Thanks a lot, Kyoung Min, because we are speaking in particular of designing in the right way such tools. That is often an issue because the people that create these are so interested in seeing how it works that often don't think about the legal implication of the usage of AI. We have seen this a lot also for what concerns the usage of personal data by those type of tools. And going to something that is connected to these, as we can consider some sort of images like personal, and I'm thinking about in particular portraits of famous people like celebrities or public figures. My next question and last question for you would be related to this. So what's the issue when you use an image that is created by generative AI, which contains then portraits of famous people and celebrities? What can happen in that case? Because since what you said is very clear in understanding that there is a high level of risk for the let's say managers of the tool, let's say the AI tool, a bit less for users, but still there may be legal implication. What about this specific case?
Yeah, that's an excellent point, Alessandro. The use of generative AI results that are identical or similar to the portraits of celebrities and other public figures in business may constitute an act of infringement of publicity rights under the Unfair Competition Prevention Act of Korea. So this act prohibits the act of infringing the economic interests of others by using a mark that can identify such people, such as a portrait of another person that's widely recognized in Korea and has its own economic value. So the economic value represented in the identification marks of celebrities is called publicity rights, and the provision has been in effect in Korea since June 2022. And since the act prohibits the use of marks that can identify others, it could include not just portraits. So even if only a partial identification is revealed in the result of AI, it could still constitute an infringement of publicity rights if that part is easily associated with the celebrity. And more importantly, in addition, the AI generated portraits of celebrities can be used for fake news and deepfakes. And depending on the content of the image and how it is used, defamation liability may be established as well.
Sorry, I had my microphone off, but thanks a lot for this explanation as well. Now everything it's very clear. We are running out of our time, so I would like first of all to invite everyone also to check your article on this topic because you have been delving deeply into it. So we will make it available also through our channels, of course, or otherwise you can follow Kyoung Min or contact Kyoung Min directly via tools like LinkedIn or our email address. Of course, ask for lawyers support whenever you are going to deal with those type of technologies to make sure that you are compliant and everything is in the right place, because fines and risks behind are pretty high, also for what concerns reputational damage of your person or your company as well. So this is something that everyone should be aware of. I think Kyoung Min is the perfect expert to support you in making things in the right way. So Kyoung Min, thanks a lot for being with us today. It's been a great pleasure having you with us, and I very much look forward to our next Privacy Espresso together. I'd also like to thank our listeners for being with us, and see you all next Thursday with the next episode of the Privacy Rules Privacy Espresso. Thank you.